you so much.
Thank you, Netta, and I'm absolutely thrilled to be here. I have truly enjoyed this past year interacting with the students here at Penn Law School. It's been a fulfilling experience for me, so I'm thrilled to be back. This afternoon we're going to talk about pot, specifically the Cannabis Conundrum. And it really is a conundrum. And why is that? Well, under federal law, marijuana is a Schedule I controlled substance. And what that means is that there is, according to the feds, no accepted safe medical use for the substance and a high potential for abuse. And that means it's illegal. But nevertheless, as you can see from this map up behind me, the vast majority of the states have taken a somewhat different view. If you look at the dark green states up there, 9 of the states in this country have legalized marijuana for recreational and medical uses. The bright green states have all legalized marijuana for medical use. The lighter green states have legalized marijuana, but with controls on the amount of THC, which is the substance that everyone's concerned about, limiting the amount in what can be prescribed. The kind of pinkish, no color states are the ones who still prohibit it. And you can see there's only 4 of them. And then the states with Ds on them have decriminalized marijuana. So what is happening in the states is diametrically opposed to what is happening on the federal level. Adding to the confusion here is the fact that the Congress has passed since 2014 every year a rider to the appropriations legislation saying that the Department of Justice cannot enforce the federal laws prohibiting marijuana in those states that have legalized it. So you've got that federal pronouncement in contravention to what the federal law is. You also had a couple of years ago something called the Cole Memorandum, which basically was an instruction from the Department of Justice to the U.S. attorneys in the various states to kind of ease up on marijuana prosecution. Basically, don't go after people using or selling marijuana in small amounts unless there is some overriding federal law enforcement purpose, such as they're selling to minors or they're big drug distributors. The Cole Memorandum was just guidance from the Department of Justice. So a couple of months ago, Attorney General Sessions repealed the Cole Memorandum. What that means is, who knows? It doesn't mean necessarily that the feds are going to go after the use of marijuana at the state level. It basically means that you revert back to the status quo before the Cole Memorandum and really allow the state U.S. attorneys to have more discretion. So this program is going to examine this conundrum in a bit more detail. There are competing policy arguments on both sides, and we are thrilled to have 3 experts here to probe into those competing arguments. To my far right is Professor Mark Clayman, who is a professor of public policy up at New York University. And Professor Clayman literally wrote the book on marijuana regulation. He is going to be talking about the most compelling arguments on both sides of the debate. And given this conundrum that we've got, how are the states dealing with this? And what are the upsides and downsides of the various state options? in the middle is Professor Peter Conte Brown, who is Professor of Legal Studies and Business Ethics at the Wharton School here at Penn. And Professor Brown is a known expert in federal banking policy and has recently published an issue brief and is soon to publish a law review article, I believe, on policy barriers to marijuana banking. Basically, this is an industry that spins off a lot of cash. What do you do with it? Well, you can't stick it in your mattress. But as it turns out, you can't really bank it either. So this is a real problem for the industry. And finally, to my immediate right is Judge James Collins. He's a senior judge on the Pennsylvania Commonwealth Court, which is the court that has jurisdiction over any challenges to the medical marijuana law that the state of Pennsylvania passed 2 years ago and the accompanying regulations. And as it turns out, there are challenges. There's one right in front of his court as we speak. So Judge Collins will discuss what is the state of the law in Pennsylvania and what are the challenges to the state that this tension between the federal policy and the state policy present. So, Professor Clayman. Oh, before you come up, I'm going to ask each of the three presenters to make their presentations, and we're going to reserve time for a conversation with you all. So please hold your questions until the end. Thank you.
Thank you for that kind introduction. Thanks for organizing this, and thanks to Nettie for making it happen. I'm always a little uncomfortable when I'm introduced as the person on the far right. But in fact, over time, my position in this debate has drifted a little bit. I would say that when I started on this a long time ago, my views were somewhat, if being in the direction of less restrictive laws is the left position, I was to the left of most respectable opinion. And without changing my opinion much, I'm now to the right of most respectable opinion. So I'm going to try and explain why that is. The case I'm going to try and make in the next 10 minutes or so is that the Congress should act right away to legalize the production and sale and consumption of cannabis at the federal level, and that it should do so in order to reduce the extent of drug abuse. So I'm going to try to work out the details of that paradox. This is a law school. Our topic to some extent on this panel is federalism. I'm the token non-lawyer on the panel, though I play one on TV. So I'm mostly going to concentrate on the factual situation. But I want to note two facts that are especially relevant to the federalism question here. One is the disproportion in law enforcement manpower. There are 500,000 state and local cops around the country. They probably spend between 10 and 15% of their time enforcing the drug laws, so that's 50 to 75,000 full-time equivalent drug enforcement officials. The Drug Enforcement Administration, which is the main federal agency in the area, has 4,000 agents worldwide. So the basic federal fact here, as opposed to federal doctrine, is that the Congress has not given the executive branch enough resources to enforce the drug laws unless the states want to play. And in fact, the Controlled Substances Act embodies a federalist principle in statute by directing the Attorney General to cooperate with state, local, and tribal officials. And there's an argument that the Cole memo was, in fact, which only protected, slightly protected cannabis production and distribution in states where it was legal, that was more or less required by the statute the statutory requirement that the Attorney General cooperate with the states to carry out the purpose of the Act. And the purpose of the Act are listed as reducing substance abuse and controlling illicit markets. And it's arguable that state level legalization does those things. So, one fact is that the feds can't do this. If the Obama administration had decided, or if the nameless administration should decide right now to crack down on state legal systems, it could do so. Using the injunction route with relatively little federal resources, you could shut down every legal producer and seller of cannabis, that is state legal producer and seller of cannabis. Every application for a license is an application for a license to commit a federal felony. You take that into district court, you get an injunction, you use the contempt power to enforce it. All right, we've now destroyed the legal, quasi-legal business. But if the states don't want to enforce it, the feds can't do anything about the illicit business. So all you do by doing that is replace a somewhat regulated and taxed business with a completely criminal business. That doesn't seem like a very good option. And again, not clearly consistent with the statutory mandate for the Attorney General to cooperate with the states. The second big fact here that argues for federal intervention is the fact that cannabis is relatively compact compared to value. So a pack of cigarettes weighs an ounce. In a very high tax state like New York, costs $12 or $13. An ounce of cannabis costs $300. New York City can't collect a $5 a pack tax differential from Virginia. About a third of the cigarettes sold in New York are smuggled in from Virginia. So I conclude from that states will not be able to collect any tax that's even trivially higher than the tax in an adjoining state. So New Hampshire will wind up setting the tax for the country, the way South Dakota sets credit card regulation. As we've seen from cigarettes, people are not especially reluctant to buy legal but untaxed and therefore illegal commodities. So the state-by-state process, it seems to me, leads to a race to the bottom. Laboratories of democracy sounds like a wonderful idea until you remember that Dr. Frankenstein also had a laboratory. All right. So the general facts about cannabis I think we need to deal with is, first, prohibition is broken. We are with cannabis where we were with alcohol in 1930. An attempt to suppress the use of a somewhat dangerous drug that was somewhat successful for a period of time. It's not well known that under prohibition, cirrhosis rates dropped by a third in the early parts of it. We don't have domestic violence numbers, but they were probably down too. But the illicit market has now grown to the point where the drug involved is widely available, and the market is larger than any plausible law enforcement effort could control. Especially given the impatience in the country with mass incarceration and intrusive law enforcement, a $40 billion a year illicit market. The cannabis market is now by far the largest of the drug markets. 20 years ago, it was a third the size of the cocaine market. Now it's 3 times the size of the cocaine market. So again, even if there were a desire to crack down on cannabis, the number of people you'd have to put in prison to actually drive people out of that business, I think exceeds anything people would tolerate, even if people were willing to spend the money, which of course the states aren't. So I say prohibition is broken. We have to figure out what replaces it. Now, the view of the legalization advocates is, well, that's great. Cannabis is a harmless natural weed that never killed anybody. And of course it ought to be available to everybody, so what's the problem? Well, the problem is that, like any other intoxicant, a certain fraction, not most, but a fraction of the people who use it wind up losing control over their use. Right? The technical term now is substance use disorder. There are about 4 million people right now in the country suffering from cannabis use disorder. Probably not on average, not as bad on average as the people who suffer from, say, alcohol use disorder. And if cannabis were a substitute for alcohol, that would be an overwhelming argument for making it legal and cheap. And I thought it was, but the evidence is not there. Coors Brewing is not complaining that they can't sell any beer in Colorado, and that seems to me pretty conclusive. The number of people who use cannabis has only gone up about 50%, according to the surveys, in the last 25 years. But the intensity of use has changed radically. In 1992, of the people who on the survey reported having used in the last month, 9% reported having used 25 days or more in the last month. Right? That's the potentially problem use group. When you ask those people the diagnostic questions in the survey, about half of the daily, near daily users look like they've got a cannabis problem by their own account. Right, that 9% number led me to say it's not really a problem drug. 9% of anybody will do something stupid about anything, go back to sleep. That number is now 40%. The modal pattern of cannabis use among people who smoked it all last month is being stoned all the time. That seems to me like not a small problem, especially given the potency of contemporary cannabis. Heavy use of cannabis is clearly elastic price. Moderate use probably isn't, because the stuff is so cheap. I mean, if you're a weekly cannabis smoker, you're not spending any noticeable fraction of your budget on cannabis. And in any case, the Doritos cost more. So it's hard to see that a drop in prices or equivalently an increase in THC content where the price of the ounce stays the same. Not clear that it's going to impact the number of users. But if you're a heavy daily user, you can be spending $3,000 or $4,000 a year on cannabis. You're likely to be sensitive to price. And there's probably somebody who's not smoking 3 or 4 joints a day who might be if a joint cost a nickel. So that's the next key fact. They don't call it weed for nothing. The natural price of cannabis is extremely low. It's not very hard to grow. Even the fancy stuff, not very hard to grow. And a joint is a little bit of dried plant matter in a wrapping. That sounds to me a lot like a tea bag. Tea bag at the grocery store costs a nickel. When Washington, Colorado legalized in 2012, the RAND drug policy crew and John Calkins and I, who all worked together on this stuff for a long time, predicted that the price would go way low. Bo Kilmer said the farm gate price would be about $1 a gram compared to what was then the illicit market price of about $10 a gram. And all the people in the industry said, oh, no, that's nonsense. You just don't know how hard this is to grow. Growers in Washington state right now are struggling to get $1 a gram at the farm gate for highly potent sensimilla. And that's not the natural bottom. Ad valorem taxation as a fraction of retail price, does nothing for that problem. Because 30% of epsilon is epsilon. The only way to keep the price high, which it seems to me is an objective, if you want to control substance use disorder, is to tax by THC content. Difficult because the chemistry of measuring the content of a chemical in a non-homogeneous solid is not trivial chemistry. But I think that's a soluble problem. And again, I want to argue that that tax would have to be a federal tax. I think the relevant tax is going to be something like $75 per gram of THC, which turns out to be $7 or $8 per gram of cannabis. You can't collect a $7 a gram tax across, if there's a $4 a gram tax on the other side of a state line. Other key fact is the 80-20 rule. Familiar from lots of phenomena, 80% of the people, 80% of any activity is accounted for by the 20% of the people who engage in that activity who engage in the most of it. That turns out to be true across a very wide range of human experiences. It's known as the Pareto rule because he discovered it about land ownership in Italy. But it's the reason the airlines have frequent flyer programs. Cannabis is certainly subject to that rule, possibly even a little bit stronger. It looks as if those daily, near daily users, who are 8 million out of the 40 million people who report having used cannabis in the last year, account for at least 85% of the physical volume and the revenue of the cannabis industry. So that gets to the next point. If there's a commercial industry selling a commodity with an 80-20 rule, then all of their attention goes on those heavy consumers, which in public health terms is the people with the drug problem. They're financially dependent on the people who are chemically dependent. And so if you set up a commercial business, you're setting up a bunch of smart people to try to figure out how to create and sustain more substance use disorder. That does not sound to me like a sensible policy approach. It's the one we used for alcohol with, I submit to you, disastrous effects. Right? We legalized alcohol 85 years ago. The one addictive intoxicant that's actually legal to sell. And I want to ask Zippy the Conehead's question. Are we having fun yet? Alcohol kills about 100,000 people a year. So slavishly following the alcohol model seems to me just pointlessly repeating a mistake. There are ways to legalize without commercialization. John Calkins and a bunch of us did a report for Vermont on that theme. You can find it on the RAND website. We identified 12 options for cannabis policy. And the only point I want to make is that commercialization, which is the one that's being adopted in all of the legalizing states except Vermont, is the most extreme policy. We are lurching from one extreme, complete prohibition, to the other, complete commercialization, without trying any of the moderate options in the middle. So I conclude that we shouldn't commercialize. We are commercializing in the states that are legalizing at the state level. We're therefore creating an industry with a lot of money and a very strong interest in maintaining policies that allow them to make as much substance use disorder as they can. If we keep doing that, by the time we get to national legalization, the cannabis companies will be writing the law through their lobbyists. There actually is a trade association called the National Cannabis Industries Association. I met their lobbyist in the winter in Washington a couple of years ago. He was literally wearing a camel's hair coat. I didn't know those things existed outside the movie. It was like somebody had called Central Casting and said, "Send me a sleazy lobbyist." And that's now the way I resolve my original paradox. The only way we're going to get control of what could be a pretty nasty drug problem is if Congress legalizes now and taxes at the federal level, or at least creates minimum rules for state level legalization. Because if we continue to go the state by state quasi-legalization route, we're going to maximize our problem and minimize the benefits of control. Thank you.
Well, it's a pleasure to be here on this side of Walnut Street. I don't come to the law school often, but to talk about marijuana. How could I resist? I was disappointed though that Doritos were not part of the lunch display. We heard some statistics about the number of police officers in the United States. We passed an important milestone in banking history in 2016, and that is that there are now more bank compliance officers than there are municipal police officers in the United States. The business of bank regulation and bank supervision is thriving. It's massive. It's a huge undertaking. And anytime any one of you participates in the financial system, swiping a credit card, using Venmo, right, getting a loan, onto the much bigger transactions that banks in the financial system provide, you are interacting with, directly and indirectly, that bank regulatory and supervisory model. It is vital to the functioning of commerce. So this isn't just about finance. This isn't just about the 2008 crisis, when we become acutely aware of how central banking is to public policy. This is about commerce everywhere we see it. My PhD is in financial history, and there's a big debate among economic and financial historians as to whether or not growth drives finance or finance drives growth. But there is simply no question as to their correlation. You don't get significant economies and industries absent a robust financial system. Again, the causal link is harder to discern, the correlation isn't. And so what we have right now, what we're undertaking in this cannabis experiment, right? This experiment in federalism, as the title of our panel suggests, is an incredibly intriguing one, and it seems to be Brandeisian, right? Mark alluded earlier to this idea of laboratories of democracy. Those are what the states do. That's what the federalist system is good for, we presume, right? But we are actually not getting that experiment in cannabis, not even close to it. And the reason is because of banking. That ubiquity of having robust financial services is cut off from marijuana-related businesses because of the unique stature of banking in the Federalist schema. Let me say a little bit more about that and make sure I end a little early so we can have plenty of time for debate and discussion. We have what's called a dual banking system in the United States. This refers to, it's kind of federalism light. The idea is that banks can choose which charter they prefer. Since 1864, we have a national charter, so not subject to state supervision directly, or you can have a state charter. So it all sounds good. This sounds like federalism, right? The problem is that since 1913 and increasing through various major pieces of legislation, even those banks that are state chartered, so subject to the laws of their state, increasingly have to open their doors to federal bank regulators and supervisors. This isn't new. This is 100 years old. The Federal Reserve System was created in 1913. The FDIC, Federal Deposit Insurance Corporation, in 1933, made permanent 2 years later. Dodd-Frank extends the reach of these federal banking regulators even into the affairs of state banks. There's a good policy logic for this, and I'm not arguing against that. But the reality is that even for those institutions that are chartered under state laws, that must be compliant with those state laws, are still subject to federal banking supervision, right? So even if you're a state credit union, for example, chartered under the laws of your state, to do legal business in your state, there's this whole nettlesome question about how to be a federally legitimate banking institution. So this came to a head in a recent litigation between Fourth Corner Credit Union established under the laws of Colorado, with the firm and very public support of the Colorado governor, the Colorado state banking supervisor. And they created a business to serve the financial needs of marijuana-related businesses. It's a credit union. This is a slightly different capital structure from other kinds of financial institutions. It's owned by its depositors as opposed to by its shareholders. And the idea here again is to provide some legitimacy and to resolve the very serious financial services needs of marijuana-related businesses. Earlier Nancy has said, what do you do with the cash? You can't stuff it into your mattress, but that's indeed exactly what marijuana-related businesses do in the absence of federal participation in banking services. I talked to one marijuana-related business entrepreneur who said that she pays taxes in the state of Washington by bringing cash in a paper bag into the tax office. It's intriguing. I wonder what bandits make of that path as she walks from her business with her paper bag. Easy pickings, I think, from a security perspective. And indeed, that might be the most rudimentary entree into this world, but absent having a bank, then all you're doing is using money to try and safeguard that cash in other ways. And cash storage becomes extraordinarily difficult. And if it can't be put into and enter into the stream of commerce through financial services, then we get the Breaking Bad problem. My references get dated at each passing day, which is so painful to me. but you're familiar enough with Breaking Bad, it's not been off the air too terribly long, right? That when you are in black or gray markets that generate a huge amount of cash, you've got to figure out a way for that cash to go back into the system. And if you're a 2-bit hustler selling joints to your friends in high school, then your cash generated goes to your Dorito fund, right? There's not a lot of need for storage and maintenance of cash in that business. For large corporations, right? For any entrepreneur that has any kind of ambition for growth, you've got to have a different model. Well, so back to Fourth Corner Credit Union, they created this. They're utterly transparent about what their ambitions were, and they were extended a charter under the state of Colorado's banking laws. But they then had to turn to the Federal Reserve System to get what's called a master account. Now, a master account allows any financial institution to participate in the financial in the payment system. This means that their accounts can be linked to other accounts, which makes it so that you can transfer money from one person to another, even if you don't have the same bank institution, even if you don't have the same employer. We take this for granted. Anytime you use your credit card, you don't think about the extraordinary technology that undergirds your success in getting the things that you want using the payment system. But indeed, this is one of the marvels of the technological era, and without a master account, you can't participate in it, right? So master accounts are normally, there are 2 questions that the Federal Reserve, the local Federal Reserve Bank, ours is in Philadelphia, for Colorado it's in Kansas City. 2 questions they ask. Number 1, is your charter valid? Meaning, has the state, or in the case of national banks, the comptroller of the currency, the appropriate chartering agency given you a charter? That's easy to verify. The answer is yes. The next question is your paperwork for the master account complete? And that answer is almost always yes. These things are turned around in usually a matter of hours. Very quick and pro forma. 9 months after the Fourth Corner submitted its legitimate charter with complete paperwork, the Federal Reserve Bank of Kansas City denied its request. Fourth Corner sued, lost in district court. The Federal Reserve said that this is the same as if this credit union were transparently and brazenly saying we seek to do business with North Korea or traffic in giant pandas, right? Both are illegal. And so we can't support a business that is claiming to engage in illegal behavior. The 10th Circuit reversed the district court on a 3-judge panel issuing 3 different opinions. For those law students here sometimes struggle to see what the Supreme Court has done in a 5-4 decision with concurring opinions. There's a whole legal doctrine associated with discerning what the majority view is. It's near impossible in this case. So we don't have clarity at all from a financial services perspective. Well, what does this mean? We've heard mention of the Cole memo and Attorney General Sessions' withdrawal of that memo. We've heard discussion about the incoherence of having experiments in each state when the federal policy is moving in a different direction. And I would say, this is the article of the title of the Law Review article, this is just simply an illustration of the impossibility of marijuana federalism, right? It simply cannot work. These are not experiments, right? Those marijuana-related businesses who feel that they are enlivened and liberated to pursue this business model are wrong. An alternate title to this article I thought about was High on Your Own Supply, because in fact there's no end game here short of federal legislative change. I'm intrigued by Mark's proposals, and I think that there's a lot of substance to them. I look forward to debating them. I think that we are not in a position where we can abandon the Federalist experiment because we haven't really begun it. And I think that there is an important question. I don't have the expertise here. I'm certainly a novice compared to Mark and many others around this question. Here it is. Is marijuana more like tobacco or is it more like heroin? Right? I have no idea. I will tell you honestly,
which of those do you regard as more dangerous?
Well, that's interesting. I would say heroin, but maybe that's a question to be begged. I have no personal experience with marijuana, honestly, really, except that when I see my students who come and I suspect they are high, I become much more a prohibitionist than an abolitionist. But again, this is an amateur assessment, and I think that those who have certainty about what marijuana is and what it does I think at least I think that a little bit of epistemic humility might be in order to see what an experiment might look like. And the way to do that is to allow states like Utah to differ from its neighbor Colorado, and Colorado to differ from Utah, but with a viable experiment that allows participation in the payment system. Let Idaho, which is culturally so different from Washington, to have that different policy. And those kinds of efforts do lead to natural experiments that I think might generate more knowledge than we have today. I look forward to our discussion.
Hi, my name's Jim Collins. I am still, for the time being, at least until I finish my address today and the Supreme Court gets wind of it, I'm still an appellate judge on the Commonwealth Court. I brought this, I carried it out here at great stress to my heart. This is a copy of the Act and the regulations for the Act. As you can see, they're somewhat lengthy, and I will confess, I haven't read all of them. I must tell you, since I'm not sitting on the panel that is deciding the legality of the contesting the manner in which, I'm going to call it dope, I'm a creature of my youth, with the dope laws administered, I don't intend to read it all. I read too much already as far as I'm concerned. When I was a young assistant district attorney under then Philadelphia District Attorney Arlen Specter, we were soldiers on the war against drugs. This was beaten into us. And I must tell you, we have lost the war against drugs. And I have proposed this to my colleagues. I have said this, unfortunately, as a eulogy for the children of at least two of my friends who died from heroin overdoses. It was the fentanyl that's mixed in with the heroin that killed them. And these were really nice kids. I will tell you this, back in those days, everyone was concerned with marijuana. Everyone was concerned with all sorts of drugs. And we were locking up as many as we could. We were sending them to jail. This didn't stop anything. Certain drugs are addictive. Addiction's an illness, I can tell you that, believe me. It's an illness. So we were doing everything we could to lock everyone up. It has failed. While personally, I don't favor the legalization of marijuana for non-medical purposes. Believe me, it's going to happen. It's going to happen a lot sooner than we anticipate. Already, de facto, dope is legal here in Philadelphia. The DA has said he's not going to prosecute, not even small amounts. I mean, if you have 10 pounds and you look like you're distributed, 10 pounds is still probably enough to smoke up. It used to be for a week, West Philadelphia. Now I'd say it lasts for a day in West Philadelphia. I've told this to my colleagues. They don't listen to me anymore. They think I'm a doddering old man. I said, we've lost this war against drugs. You have to retract. You have to think of the future. And no, they come from all over Pennsylvania. Some of them come from very conservative backgrounds. I want to give you an example first of what I think is truly hellacious. Most employers now, particularly school board employers, if you get injured on the job, they test for alcohol and drugs. We've had cases where school janitors have been in an accident, injured themselves on Wednesday morning, Tuesday morning. They go seek treatment. They get treatment. They do a blood test. And they find THC. They find cannabis in their blood systems, and they fire them. They say they are morally unfit to teach our nation's youth. Well, I want to tell you something. Here in the Philadelphia suburbs, and again, this is a radical statement, but most of our nation's youth are smoking dope. You can ask the police force, you can ask the school. Unfortunately, a lot of the school teachers are smoking dope. We have a lot of discharge cases involving that. So now we're going to talk about a case study after I've editorialized for too much of my time, so I apologize. The case in Pennsylvania is Keystone Relief, RELEAF, LLC, petitioner versus the Pennsylvania Department of Health, Office of Medical Marijuana, and then the 27 people who got the licenses. Needless to say, Keystone Relief, LLC, didn't get their license. If I were their attorney, I would say, change that name. You're making a play on words that is not offering relief, and I would demur to the Wharton professor on that. Its docket number is 399 MD 2017. Keystone Relief was denied not only the permit. We have two types of permits now in Pennsylvania in medical marijuana: a grower distributor license and a dispensary license. You can apply for both, and the fee to apply for both is $15,000. $10,000 for the distributor license. There were 447 applicants for the variety of licenses. I think this shows you that there is a lot of money in the growing and distribution of medical marijuana. And again, not based on the law, Jim Collins' subjective opinion that eventually Pennsylvania, although Jim Carville said that, you go between Philadelphia and Pittsburgh, it's Alabama. Having been in Pennsylvania all my life, I don't like to see those Alabamans slurred like that. That's all I can say. And I'll tell you this much from my work. There is more or as much per capita marijuana and hardcore drug use in Lancaster County, the seat of our legendary Amish population, Pennsylvania Dutch, and extremely conservative Germanic population, than there is in Philadelphia. The arrests show up. State policemen have been locked up for selling this stuff. Local cops are all involved. I'm ranting and raving, but there's a lot to rant and rave about. Now, Relief has brought this action under what is known as the Pennsylvania Declaratory Judgment Act, and also a complaint in equity. They're represented by a very fine firm from the Allentown area. I recognize from the names. Oh, by the way, I have had absolutely nothing to do with this case, and I informed my colleagues that I was speaking here, and there used to be a term in the law, but of course it's now a racist, politically incorrect term. You can't use this term anymore, Professor. The Chinese wall, build a Chinese wall around between myself and this case. I'm quoting that. If you were to use that term now, teaching in this law school, I think you'd be run out of town on a rail. I think I don't know what we can call it, but anyway, I said I don't want to have anything to do with this. Don't tell me about this. I do know that this case was argued in December, and there has not been a draft opinion circulated. I assume that is because it's being hotly contested. After the passage of the act, the respondent, that being Department of Health, Office of Medical Marijuana, issued 27 dispensary permits of the 50 available, and they issued 12 grower processor permits of the 25 permitted by the act. Now, this is again my natural cynicism on this. For some reason, they divided the state up into areas, divisions. You'd have 6 districts where you'd give out the license. Well, the state Senate used to divide things up. You used to have to get your state senator. You still do, to approve your application to be a notary public. I hate to suspect that there might be some political influence in awarding these permits. I think you're right. Professor Clayman says no, and
Pennsylvania?
you're right. Okay, now, the allegations, and I've read the complaint of the protesters, the petitioners, they do leave out one minor fact. They didn't submit their $10,000 with the grower, or no, it's footnoted. It's footnoted in their petition. They didn't submit the $10,000 check with their application for a grower distributor, but they sent the $5,000 in to be a dispenser. And the claim is, respondent, that's the Commonwealth, respondent's permitting process denies all medical marijuana permit applicants their fundamental constitutional right of due process to fairly and meaningfully challenge their denial of a permit by way of administrative review, making the respondent's permitting process unconstitutional, inherently inequitable, and all of the respondent's applications in connections with the permitting process unlawful, ultra vires, arbitrary, capricious, and unreasonable. Now that's pleading. I like that. They're not holding anything back. The concept of administrative due process, which essentially this case says they were denied, and I distill these things down. My colleagues hate me for this. But again, administrative due process is 2 things: notice and an opportunity to be heard. That's it. There's a lot of ways you can spin that into why you were denied notice and opportunity to be heard. Well, they said they weren't given a hearing on their license or on the denial. I don't think anyone could know. They weren't giving anyone a hearing. You have 457 applicants. You're not going to get that many people to hear them. They claim that, they don't claim, they state that the persons who weighed in on the licensing procedure, they don't know them. How could they make a claim of bias if they don't know who denied their license? I'm not allowed to say this, but that sounds like a pretty good argument to me, but I don't know how my colleagues are going to vote. There was a 1,000-point scoring process according to what was set up by the board, and this I think is even dehors the regulations. This is one of the first acts that I've seen. Regulations were passed with the statute, but they were all temporary regulations. They were all to sunset after a certain date, and they were going to pass regulations. Not all of the regulations have been passed, but I think the sunset date was March 17th, so I don't know what statement we're in. They also allege, and for the practice of law, allege as many things as you can, as long as it sounds like, they said non-compliance with the right to know act. I love this pleading, further exacerbating the permitting processes, lack of transparency, contributing to the lack of a meaningful administrative review, and the denial of due process to permit applicants, and further rendering the permitting process arbitrary, capricious, and unreasonable, and lacking the forces of law. We're getting back to notice and opportunity to be heard. The first case to establish administrative review of a government taking or government denial was the sloop Lucy B. And that was the Coast Guard seized some ship in, I don't know, 1790. I think it was one of Stephen Gerard's ships. But I think they said it had contraband, illegal whiskey. Probably had some dope on it too, because it was coming up from Jamaica, but I'm not as much of a historian to talk about that. Well, we all know the complaints about the slowness of the judiciary. This case, I think, was actually decided, Lucy B., I think it was 60 years later. It was the estate of the owners of the sloop Lucy B. that won. And the Supreme Court said the Coast Guard just can't go grab things, seize the contents, and dispose of them. You have to tell the owner you're seizing the ship. You have to tell what you're doing with the contents. The arguments are lack of due process, no notice, and an arbitrary and capricious process. Now, the Office of Medical Marijuana is represented, again, very fine law firm. And I guess I'm allowed to use their names. One of the attorneys representing the petitioner is Judge Friedberg, retired judge. He's even older than I am, and he's still making a good living. A brilliant man. The reason I was Judge Friedberg, when you pass the bar, you will get an attorney's license number, and I think you will be in the 300,000, a 6-digit number. Judge, the reason I know this was the same Robert Friedberg. He has a 4-digit attorney ID number. Mine is even 20,000 something, so it had to be Judge Friedberg. The chief argument of the Commonwealth, and it's the judge's friend, appellate judge's friend, they failed to exhaust their administrative remedies. And we don't want to write opinions. We don't want to do this. We want to remand everything with an admonition to everyone. Failed to exhaust their administrative remedies. Administrative remedies are very important. It was built into the statute. Otherwise, why have these agencies? Why have these regulations? Because there is, Pennsylvania law is standard, and I assume it's this way in the federal government, that an agency's interpretation of its own regulations is to be afforded great weight. It starts upon a well-known presumption, the presumption of governmental regularity, and the fact that these people are not out to do evil or harm to the citizenry. Unfortunately, in this case, as is pled, we don't know who these people were. So that makes things quite difficult. For all we know, maybe they were throwing the papers on a step, and you got the high step, you got 50 points for that. I do not think this particular case will end itself, I don't want to say in my lifetime, I don't want to jinx myself, but as Governor Hickenlooper, who was on TV this morning, and I think he's going to run for president. He looked very candidated to me. I remember the night this legalization of marijuana occurred in Colorado, and he said to the whole state, don't break out the Cheese Whiz and Doritos yet, because it's still against the federal law. And it's still, this distribution of marijuana under this incredible legislative scheme is still against federal law. And happy to answer questions, and don't be afraid to throw things at me if you don't like what I did. I'm used to that.
Okay, we do have time for questions, if there are some. But actually taking the privilege of being the moderator here, I'm going to ask the first one so I can get one in. Professor Conti Brown posed the question of whether we should regulate marijuana more like tobacco or like heroin. And I think that's an important question because it raises several different issues. If it is regulated more like tobacco, whether it's on the federal level or on the state level, that is the pure commercialization model. Anything goes as long as you follow the rules. If it's regulated like heroin, that would argue for changing the Class 1 status to a Class 2 or Class 3 status under the Controlled Substances Act. So my question to you, Mark, is what would be wrong with just changing the category, the classification?
Yeah, I need to unpack that a little bit.
Okay.
So to say regulated like tobacco, you need a time subscript. What you just described, the full commercialization, is regulated like tobacco circa 1955. Then there's regulated like tobacco today, where every state, federal, state, and local government has as its purpose reducing the number of people who use cigarettes. They use taxation for that, they use regulation for that, they make smoking uncomfortable, they make it inconvenient, they make it socially unfashionable, they spend money on telling people not to smoke. They do everything short of prohibition. Oh, and they make it fantastically expensive through taxation. Doing everything short of prohibition to discourage smoking. And now the Food and Drug Administration has proposed a regulation to limit the nicotine content in cigarettes, which would amount to cigarette prohibition. Right? So I call that set of policies grudging toleration. Everything short of prohibition. And that seems to me like a fine set of policies to use for lots of different things. The out-of-control commercialization is what we currently do with alcohol. Right? So if you ask an alcoholic beverage commissioner, how many people in your state have alcohol use disorder, or what fraction of 16-year-olds are drinking, or what fraction of domestic violence events involved alcohol, he's going to look at you like you had two heads. No, my job is making sure that the taxes are collected, that the premises are orderly, and that licensed vendors do not sell directly to minors. That's my job. If you're worried about public health, go talk to the health department. Cannabis regulators are looking like that. They're obeying a set of rules designed to keep the industry orderly and to make sure the tax revenue comes in, not to protect the public health. So Stan Glantz, who's a leading tobacco researcher with whom I disagree on tobacco policy, said, I think, the right thing, that the problem with cannabis policy is that we are moving toward the alcohol model, not toward the tobacco model. And it's the tobacco model I'd like to see us move toward. Heroin, by the way, is not regulated in this country. In Canada and the UK, it's a regulated pharmaceutical drug. In this country, it's Schedule 1. We do not recognize the medical use of heroin. Rescheduling cannabis would do precisely nothing. All rescheduling means is that if the FDA approved some cannabis preparation as a drug, it could then be lawfully prescribed. Cocaine is a Schedule 2 drug, not a Schedule 1 drug. Doesn't mean we don't have a drug war about it.
Okay, but rescheduling it would at least allow the FDA to start looking at approved uses and allow some experimentation. Yeah.
Hi, my name is Andrew Peterson. I appreciate that recognition that it would allow the FDA to do more. What we're lacking right now, why it's a Schedule 1 drug, is because it has no medically approved use. Researchers are handcuffed right now because it is a Schedule 1 drug, and there is no ability to be able to do good clinical trials to determine the real medical benefit, if one exists, for that drug. To me, if we did move it from a 1 to a 2, it would at least allow federally organizations, universities, and medical centers and stuff to conduct research that would then allow it to be proven or disproven, or focus the research on those diseases where it would have the most benefit. Right now, Pennsylvania has 17 diseases that it allows for, and then they're considering adding more with very little to no evidence for its basis. It's only conjecture, and the researchers and the clinicians, the prescribers and the dispensers are going on the seat of their pants to be able to prescribe, recommend, and dispense this drug. I'm really interested in what's the liability to those healthcare practitioners who are making those recommendations, and more in particular those pharmacists who work in the dispensaries in the Commonwealth of Pennsylvania for dispensing those drugs. What's going to happen to them, their license, and their liability should something bad happen to those individual patients? Sorry, I'm reading.
I think you've pointed at the right problem, but the wrong barrier. It's perfectly legal to do medical research with Schedule 1 drugs. Any drug before, any abusable drug before it's FDA approved is Schedule 1. Putting cannabis in Schedule 2 before it has a recognized medical use would contradict the statute. So the barrier to medical research is not the Schedule I status. It's the fact that under a separate set of rules, the DEA has restricted production of research cannabis to a single site. Rescheduling wouldn't fix that. The Obama administration announced a competition to open up additional medical research growing sites for medical research, which would mean that you could get research product that's more like what's on the market than what's referred to as Mississippi mud with the current product. That process has not gone forward under the current administration. But that's the barrier. Rescheduling, I think, is a red herring.
Comments on the medical profession and their liability. And maybe, since we're also in a law school, we can also bring in lawyers that might be advising or clients that have questions about how to conduct this business. Are they engaging in an ethics violation, if nothing else?
One problem I see, as you now know, as you all read about, they are locking up and prosecuting a lot of doctors for overprescribing opiates. In the Pennsylvania statute, and cancer, Huntington's disease, a lot of order, and there was one little phrase in there, one of the conditions where it can be prescribed for is post-traumatic stress disorder. There's a great debate in the psychiatric community as to how to properly diagnose post-traumatic stress disorder, and there are psychiatrists who specialize in treating post-traumatic stress disorders. Now, what happens when you have a psychiatrist who is prescribing a lot of cannabis, or maybe cannabis to all of his patients, treating them for post-traumatic distress disorder? I think there's a great danger that that doctor will be locked up and hit with a search warrant, as well as the dispensary that is fulfilling or filling these prescriptions. There is a danger, and I think cautious members of the medical profession will be worried about their licensing status, particularly now since you're not allowed to prescribe OxyContin, you're not allowed to prescribe Dilaudid. By that I mean, in the court of public opinion now, and law enforcement opinion, you're not allowed to prescribe that. And I see that as just that phrase, post-traumatic stress disorder. I fear that they may adopt new regulations that will eliminate what the intent of the legislature was in the act. There's a lot of people with very legitimate post-traumatic stress disorders, and I think you've all seen them. And they break down in tears at times, and when things remind them. And if marijuana helps them deal with that, God bless them. I think it should clearly be done, but I think that's a problem.
Let me just say a word about that. So, a medicine is a material of known chemical composition that has been demonstrated to be safe and effective in the treatment of some condition or symptom. Cannabis is not the name of a medicine. Cannabis is the name of a plant. That plant has at least 400 different chemicals in it that occur in no other plant, plus a whole bunch of flavonoids and terpenoids. Many of those are active, they're probably interactive. We have almost no knowledge about what they do. So if I have an infection and go to my internist, and she looks at it and says, you have an infection. I believe that antibiotic may be helpful for infection. I recommend that you take some antibiotic. I'm looking for a new internist. I want a prescription for 100 milligrams of amoxicillin 3 times a day with meals for 7 days. That's medicine. Blow some weed is not medicine. And that's not the fault of the docs. But we have not done the research that would allow a genuine prescription. Fortunately for the docs, they're not prescribing. They are recommending. And there's a Supreme Court decision that their free speech right allows them to recommend something even if it's illegal. But they can't prescribe, which means they can't even say, use this tincture at this frequency and this potency, because then they'd be telling somebody to break the law as opposed to recommending that they try something. So the current legal status is catastrophic for them. For the lawyers, I don't know how they're getting away with it. Last time I checked, a lawyer was not allowed to help a client break the law. And all of this stuff breaks the federal law. But it doesn't seem to bother the lawyers.
The ABA has a cannabis law blog on their website. So.
Well, one thing I'd say, I don't have any expertise on the medical issues there, but I am deeply sympathetic with doctors and researchers who might be in a situation where they want to know more and create more information, create more knowledge. And this is deeply related to the banking question because coincident with the Cole Memorandum, the federal banking regulators issued a guidance saying that they were also not going to, they were going to follow the Cole Memorandum when it came to anti-money laundering and bank secrecy requirements. And that was meant to reassure banks that yes, if you're in Colorado or Washington, etc., you can do and engage in this business. No banks did, or very few banks did. Why? Well, because they're risk averse and they recognize that just as a memorandum can be issued, it can be retracted. And that creates just rank instability. And it's not Jeff Sessions or Donald Trump's fault of that instability. The very fact that this is done by executive order with a promise that the law won't be enforced is the issue itself. And so I'm incredibly sympathetic with the idea that the looming cloud, whether or not there's a Supreme Court decision that supports doctors' ability to do this or that, is just going to take researchers and say, yeah, we don't want to even mess with that. Let's go to a different area entirely. And making this overly legalistic for the generation of knowledge that we need to evaluate this public policy proposal, I think is the harm itself. And so taking steps at the federal level to liberate researchers so they can generate real information about this, I think is vital, because absent that, this just becomes a clash of ideologies, more heat than light, as they say.
Amen.
One more question? That I'd like to call Professor Candelese for the last question.
Let me ask a last question of every panelist, and then offer maybe a word of thanks myself for this session and for your participation. The last question is, where do you see us in 5 years? I'd love to know. Obviously, it's speculative, but where do you see this situation just even in 5 years?
I think recreational marijuana will be legal in a majority of the states. And I think if the president after the next election is Donald Trump, and I think he will be reelected, don't throw things at me, okay, but I said he'd win Pennsylvania and be elected. If he's Donald Trump, he's going to push for that, and if the president is a Democrat, a so-called, quote, liberal Democrat, they're not going to get in the way of it. So I do think we're going to see more and more legal marijuana, and I don't think the sky will fall. I really don't. I don't think it's a Chicken Little issue, so. But people are going to make a lot of noise about it.
Other thoughts?
I think that here's my perspective as a historian. The appetite for Americans to sustain political pathology is pretty extraordinary. So I think that while a house divided can't stand forever, it can stand for an awfully long time. And so it wouldn't surprise me at all if in 5 years we still have essentially the same situation that we see with some states having shifted to a different column or another. I think the money, though, is that this becomes a wedge issue for Republicans trying to distance themselves from an unpopular president as soon as this fall in the midterm elections. We've already seen some Republicans say, all right, I differ from the administration, or at least Jeff Sessions, on this question. And I could see in 2020 this being a front of culture wars that just doesn't summon the same enthusiasms that abortion or guns does. And so I think trend lines are very clear in where they're moving. But again, the idea that suddenly the Controlled Substance Act is retired, I don't see that.
I think what Professor Gotti Brown just said is the crucial fact here, which is there's very little enthusiasm on the anti-cannabis side of this argument. That's the big change. And we learned this in 2016 when both Governor Huckabee and Governor Christie tried to make the Cole Memo an issue in the Republican primaries. They were attacking the Obama administration for having failed to enforce the rule of law. And Republican primary voters yawned They couldn't get any traction on that. So I think the energy is on the legalization side, and the money's going to be on the legalization side because you've got the industry there. I think the president elected in 2020, and I don't think it'll be Donald Trump, is going to be elected on a.
But I think you
On a, I mean, for those who favor my opinion, last night's results from Wisconsin, where effectively the Democratic candidate for the Supreme Court won by 10 points. First time a Democrat has won for the Wisconsin Supreme Court in a long time. Well, Wisconsin's one of the 3 states that asked to flip. Anyway, I think the president elected in 2020 is going to campaign on legalization, and I think the Congress that comes in will pass legalization, and I predict that it will be the wrong kind of legalization.
Well, I just wanted to thank all of the panel members for being here and sharing your thoughts with us. This has been a terrific conversation. I want to also thank our distinguished policy fellow, Nancy Nord, who's been with us for the year, for bringing us all together around this topic and identifying this as an important issue for the conversation within a law school setting. As my colleague Netta Borshansky said, this is a product sponsored by the Model Government Public Affairs Initiative. Well, thank Netta for her expert direction of that program and all that we're achieving. But I wanted to just conclude by pointing out how much this issue really exemplifies a larger purpose of our overall government and public affairs initiative at Penn Law, but also our emphasis here at Penn Law on thinking about law in an interdisciplinary manner. This is certainly an issue with great legal implications to it. And these are legal implications and issues that cut across a wide swath of areas of law that we teach here at Penn Law. Constitutional law, obviously, with federalism type issues. Criminal law, obviously, a main focus of a lot of our faculty and our courses here at Penn Law. But also banking law, real estate transactions. There's a dispute in federal district court here in Philadelphia that was just settled, but centering on a lease provision where a dispensary wanted to get a lease, but the standard lease provisions say you can't sign a lease for an illegal activity. Enormous implications across a whole swath of areas of law, and we've talked about federal food drug law, for example, very much implicated. Highly complex legal issues, but also interwoven with a whole host of political, sociological, medical, and ultimately policy and normative issues as well. So this is a great case study that exemplifies, I think, what we believe is important for understanding and contributing to law as lawyers here at Penn Law. And again, I just wanted to invite all of you to join in me in thanking the panel for their time today.